Buenas and half a day. The Committee on Health, Tourism, Historic Preservation, Land and Justice is now called to order. Today is Thursday, March 28, 2019. The time is about 10:02. On our agenda this morning is Bill number 22-35, introduced by Senator James Moylan, an act to amend 61543C of Article 5, Chapter 61, Title 21, Guam Code Annotated, relative to the erection of signs which were granted variances or a notice of action to proceed on or before May 15, 2017. I'd like to acknowledge the presence of my colleagues, Senator Terlaje, Senator James Moylan, Senator Talina Nelson, Vice Speaker Talina Nelson, Senator Sabina Perez. I'd also like to thank those who've come today to testify and those who've signed up in support of the bill. I'd also like to recognize the presence of a speaker, Tina Munya Barnes. Thank you. Before we hear from those who are here to testify, I'd like to invite the sponsors to introduce the bill.
Thank you, Madam Chairman. Welcome to the public hearing. Thank you for your attendance. This Bill 2235 is an act to amend subsection 61543, section C of Article 5, Chapter 61, Title 21 of the Guam Code Annotated, relative to the erection of signs which were granted variances or a notice of action to proceed on or before May 15, 2017. On May 15, 2017, the Attorney General provided an opinion that certain signs were illegal on Guam. However, prior to this date, the Guam Land Use Commission approved a number of variances or notice of action for businesses to proceed with their signage. These businesses were advised by this very government that they can proceed with their business activity. They pursued their investments and started setting up their signs. However, the same government that gave them the green signal to start came back and advised the entities to halt their signage. This then prompted Senator Mike San Nicolas' introduction of legislation which would grandfather those entities that were issued these approved variances prior to the date the Attorney General's opinion on Guam's antiquated sign law. So in July of 2017, Public Law 3430 was enacted. However, it was determined after that legislation just grandfathered those whose variances were for electronic signage. Those other sign variances approvals, such as static signs, were erroneously not included. So Bill 2235, which is in front of us today, is merely to correct Public Law 3430 by simply adding the words "and other" before the word signage, which was approved by Guam Land Use Commission prior to May 15, 2017. We aren't legislating the approval of new signs. Rather, we are correcting a law in which other businesses who also were given a green signal by this very government and who also made investments were told by the same government to halt their activity. We're looking forward to your public comments. Thank you, Madam Chair.
Senator Moylan. I'd now like to invite those who are here to testify to please come on up to the panel and I'll read your names. Benson Ayung, Philip Flores, Fred Haraki. I'd also like to note that Mr. Alfred Lam is here and has also signed up in support of this bill, and Pinky Lujan has also signed up in support of this bill. Mr. Ayung, if you would begin.
Thank you. Good morning, Chairperson Senator Terlaje, as well as good morning, fellow senators. My name is Benson Ayung, and I thank you for the opportunity to present my testimony this morning. A little brief history of myself. I lived on Guam for about over 45 years. I went to school at Cathedral, Bishop, and eventually graduated from FD. I went to college in Hawaii, Manoa, and eventually returned to Guam to help my father. My wife's from Guam. My kids grew up here and they graduated, and needless to say, I call Guam home. I'm here representing my advertising company called Cube Inc. And our only source of revenue is the static banner sign that is located in Upper Tumon, next to the intersection, next to the Nissan showroom company. I'm here in support of Bill 2235. So last year in May, the Attorney General Office issued an opinion that questioned the legality of the billboard signs. Then in June, Public Law 34-30 was passed into law to legalize electronic signs, which received a Guam Land Use Commission variance approved before May 15, 2017. However, there are other signs, such as Cube Inc.'s static sign, that received JLUC variance approval before May 15, 2017. Cube Inc. received ours in 2016. The static billboards of Cube Inc. is also adversely affected by the AG opinion, as questions have been raised by the official concerning the legality of the Cube Inc. static sign. Therefore, I support this bill because it amends the language of the Public Law 3430 to include the word other signs for static sign, which also received the JLUC variance approval before May 15, 2017. Bill 2235 will extend the same protection which was accorded to the electronic sign in the same law. I'm here today to ask the legislative body to also support Bill 2235, which is in line with the original intention of the Public Law 3430. The intention of the Public Law 3430, and if I can just read it out, this is from the Public Law. The Legislature of Guam finds that the existing and authorized electronic signage business have incurred legitimate costs that might cause the government of Guam to be liable, and that such business have been operating and pursuing operation in good faith. The Legislature of Guam finds that the government of Guam seeks to modernize the electronic sign law. It is necessary to ensure that those current operating and authorized to operate are not unduly harmed by the government. Unquote. That was from Public Law 3430. Now, Cube Inc. has also incurred legitimate costs, like those of the electronic signage legally protected by that public law. The costs are not just over hundreds of thousands of dollars that we spent with the signage and the foundations, but also the rental of the property that Cube Inc. still must pay for the next 10 years. Not to mention the employee that I have to let go if my business does not continue. Without the protection of this bill, the government might cease the operation of our business and attempt to force us to remove our sign. So I ask for your vote to pass this bill so that we can have the same protection as the electronic sign. Thank you.
Thank you very much, Mr. Ayung. Mr. Phil Flores?
Thank you, Madam Chairman. Madam Speaker, Madam Vice Speaker, Senator Perez, and my fellow Republicans, I'm Phil Flores, and I'm here today to testify in favor of 32-35 as corrected, which seeks to correct an error by omission, as Benson has just pointed out, and to include static signs under other signs. We have, as you know, I'm with Bank Pacific. We have 2 signs with time and temp and LEDs, one in Tamuning, one in Dedito. And they were approved a long, long time ago, both of them. But now I didn't realize, until I heard about this bill, I didn't realize we had an issue with our static portion of those signs. So this bill would correct that problem, and so I'm just humbly coming before you today to ask that you consider it very positively. Thank you.
Thank you, Mr. Flores. Attorney Jarecki?
Thank you, Chairperson Terlaje, Senators Perez, Nelson, Moylan, Speaker Munya-Barnes, and Senator Teitegui. My name is Frederick Jarecki. I'm the attorney for the Cube, Inc., and in that capacity, I've represented Mr. Al Young on many of the issues over the past few years that have concerned the sign laws. Really, when you get down to the main reason why I think this law should be passed is to prevent a perpetuation of inequality. In Public Law 3430, certain sign owners, electronic sign owners, were protected by law because they had obtained their approvals from the GLUC prior to May 17, 2017. But on the other hand, you have another group of sign owners, which include Mr. Al Young and Mr. Flores, which were not extended protection by the law. Now, I realize that there have been some senators that weren't that excited about the prospect of more signs throughout the island. But that's not the issue here, because that horse has already left the barn. In passing Public Law 3430, it protected one group, but not another group. So whether you're for signs or not, it seems that principles of equal protection should demand that there be the same protection for people based on when their notice of approval was granted. How can you say that only electronic sign owners should get approval because their notices were approved prior to May 2017, but not extend the same approval to static sign owners such as these gentlemen? You've already heard some of the history. Of course, the Cube's application was approved March 2016. Mr. Al Young, and I know because I was there, we went through the entire lengthy process of a GLUC hearing to obtain the approval. And the approval was granted. Well, in reliance upon that, Mr. Al Young then undertook the task of constructing the sign facade and foundation. And by the way, putting up a sign such as the Cube is not that easy. You know, it takes a lot of construction, technical work. We're talking about quite a bit of activity. And the sign was placed in operation in June of 2016, again in reliance on the approval of the GLUC. The Cube presents banners for advertisement on 3 sides and has functioned for that purpose up to the present time. The Cube derives its advertising income as its only source of income from businesses that utilize the sign. And the sign, as Mr. Al Young pointed out, is in Upper Tumon next to the Nissan. Well, you've heard the history of the Attorney General's letter, so I don't think I need to repeat all those facts. But the Attorney General's, and it was a letter, it wasn't even an opinion. You know, I certainly have my own thoughts about whether that was a valid letter or not. Frankly, I don't think it's correct on the law, because we have a statute that says a decision of the GLUC is final unless some party takes an appeal or a review proceeding in Superior Court within 15 days. And of course, the Attorney General's office never contested any of these variances that were granted. But I understand that's a different issue. However, the legislature, in response to the AG letter, did enact Public Law 3430, which granted legal authorization for the operation of any electronic signage that was granted a variance by the Land Use Commission prior to May 15, 2017. I'd also note it was interesting, the Director of Land Management at the hearing on the bill before it became a public law actually suggested that the law be amended to include all signage, but that apparently wasn't done. But subsequently, Senator Tom Atta, as chairperson of the Land Committee, had proposed Bill 15434, which would have extended grandfather protection to all electronic and other signs as legal, non-conforming off-premises signs, including the static sign of the Cube Inc. The bill was vetoed by the governor after passage by the legislature. So at present, as has been pointed out, the owners such as Cube Inc. do not have the same protection for static signs that was extended to other sign owners. But I would point out that this bill 2235 is entirely consistent with what the legislature approved in bill number 15434. That bill was passed, meaning that the legislature apparently intended that protection would be given to all sign owners. And I think then that by approving this bill, the legislature would merely be affirming the protection that it already approved for legal signs in bill number 15434. The Cube does face potential issues about being shut down, the same referred to in the Attorney General's letter. The Attorney General broadly stated that it's belief that there was no authority for these variances that were granted. So this is a protection that the Cube Inc. really needs to be able to proceed forward. The bill 2235 rightly points out that Public Law 3430 did not extend the same protections. If you look at the reasoning in Public Law 3430, all of it applies to Mr. Al Young and static sign owners such as these gentlemen. The government could be liable if it shut these signs down. These businesses have been operating and pursuing operation in good faith. And all of these owners have incurred considerable expense, as Mr. Al Young pointed out, over $100,000 for the construction of the sign. The rental agreement, as Mr. Al Young pointed out, is a great concern because if he were disallowed to continue operation, he could be liable himself, or the business would be liable for the rent for the rest of the 10-year term. I think, well, the other issue too in Public Law 3430 was not to unduly harm businesses by government action, and that has to be rectified here to ensure that all have the same protection. I mentioned that there are certain legal principles. I don't want to bore you with a long legal discourse, but the first is there's a maxim of law. It's something in Guam jurisprudence saying that for every wrong, there is a remedy. This was from our old civil code. And I think in this case, the remedy to the wrongful exclusion of static signs from the protection of the law is to pass this bill. This bill would provide the remedy. Finally, under equal protection of the laws, of course, all businesses similarly situated should be treated equally. How can you say that one type of sign, because it had its approval before May 2017, should be protected, while another sign that had the same approval should not? So I think it's very clear that passage of this bill is in the interest of justice, and I strongly urge you to pass Bill number 2235. Thank you.
Thank you, Mr. Harecki. I'd like to ask the sponsor if he has any questions for the panel. Senator Moylan.
Thank you, Madam Chair. So Mr. Hurricane, you mentioned, and please just reiterate there, you reviewed the current law, and the difference with our bill that we're proposing is we're not changing anything else in the current law. We are just adjusting, if you can kindly repeat that, please.
Yes, Senator Moylan, that's correct. I mean, the only real change is to just extend the protection by either correcting, how you view it, correcting or amending Public Law 3430. So I don't see this as certainly it doesn't change anything that was done in the prior law, but it rightfully corrects an omission in failing to include static sign owners.
Okay. And then just for the panel here, and thank you for your testimonies. So if this bill does not pass, basically the government is saying that these signs that were not included are therefore illegal. Would you agree to that?
Yes, definitely. Mr. Al Young testified to that. There have been issues raised about the legality of the cube. Okay. And we think without this protection, it's quite possible. We never know what will happen, but the government could well seek to shut the sign down.
And when we say shut the signs down, meaning you'll have to remove it, to include Mr. Flores'
Have to remove it, everything that's been done, and then be stuck with a lease for 10 years on the land where the sign is situated.
Okay. Mr. Flores or Mr. Ayong, if the government tells you to remove your signs because this bill doesn't pass, can you please give your comments to that?
Yeah. I'm glad you asked me a question because I want to correct my testimony. I referenced our signs in Dededo and Tamuini, and those are totally digital because the LED and the time and temp. The issues are with our sign here in Hagåtña and Agate. The time and temp is digital, the above is static. If it doesn't pass, probably what we do is we'd fill in the static portion with an electronic digital display, but then again, that wasn't approved back in 2000, before we built it, and therefore I don't think we could do that. So I don't know, maybe we just make that part dark. We're not going to take down the monuments, but we'll probably, I don't know, we'll scramble, see what we have to do, but it would cost us money, or maybe, again, we'd have to take down just that portion of the sign.
And if I can add, I know that I'm here representing Cube Inc., and it seems like there's a focus on my sign, but actually I think the intent of the amendment for this bill is not just for one particular me or Mr. Flores here, but also it actually affect all the signs in the last couple of decades that have gotten sign variants from the GRUC as well, that would actually be voided because of the AG opinion. But if we focus, but in regards to my business, if it were to be shut down, per your questions, as I mentioned, the hundreds of $1,000 investment, the lease that I have to pay for the next 10 years, and of course it will affect my employees that I have to let go.
Mr. Ayong, when you mentioned employees, can you expand? How many employees do you have, Mr. Ayong?
We have 5, yeah.
And how long have you been in business again?
Since, at the beginning of 2016, yeah.
Okay. If I may, you've been paying your taxes?
Of course, yeah.
Yes.
We pay our taxes, and if I can add, this is the main source of the income for the business. A big part of our revenue is generated from off-island clients. So we brings in money from off-island to inject into the economy of Guam too.
Off-island? Can you expand on that, please?
Our customers are from off-island. Yeah. Okay. So, the revenue comes from off-island, a big part of it.
Okay. Thank you, Madam Chair.
You're welcome. I have a couple questions. One is just, Mr. Flores, is your sign that has static and electronic pursuant to a variance?
Actually, they come from, I think it was before the the GLUC, or whatever we're calling it now, was in existence. But they were questioned afterwards, I think, when Frank Dominguez was at Public Works. And I talked to him about, do we have to take these down? He says, no, we'll consider you having a variance. All right, thank you.
All right, and Mr. Harecki, what's your reading on the code? That the code, there's no authority in the code for a variance for a static sign. I know the code did not allow at all for electronic signs. That was one of the issues that their AG raised, but does it allow, in your opinion, for GLUC to grant a variance for static signs that are off-premise signs? I think that's the difference between the cube sign and other business signs that are static, is that this one is for off-premise.
Yes. Well, I'm aware of the 1979 Attorney General's opinion that did find that there was authority for the GLUC to grant sign variances. So I guess it depends how you read the law, but I actually see the variance authority is very liberal in the law. I mean, there are certain findings that have to be made, but if those are made, I do believe the GLUC would have the authority. But, you know, if you look at our statute, it has that provision I mentioned about finality. That really concerns me, and I did the research on that. There are actually court cases that hold if somebody doesn't file for review within 15 days, that decision is final. So I think if actually the issue went to court, probably it would be found that nobody challenged these variances in a timely manner, and therefore they're final.
All right. What if, so the bill was passed, do you think that the signs are up pursuant to a variance, would the applicant have to reapply for another variance if the bill was passed? For example, if the variance had expired, would the applicant have to apply again for another extension of that? Does it?
Yeah, that's a good question. I think perhaps not. I believe the electronic sign owners have interpreted Public Law 3430 as kind of just providing a blanket protection. So I'm not sure, you know, what the status is on reapplications for them, but I think they view it as a rather a blanket.
All right. All right, is there any other senator that has questions? Vice Speaker?
Thank you, Madam Chair, for the opportunity. Mr. Harecki, that is also my concern, was the situation of reapproving, having to reapply for a variance. And so if, even within the interpretation of the law, the impacts that it will pose for other static signs, I do support the measure to move forward and to bring some parity. But I'm just trying to wrap my head around the GLUC's position and also their authority on what they are allowed to do within the law. And so when the bill came previously to approve the LED signs, the moving signs, my concern was that we were kind of usurping GLUC's authority to try to perhaps make something right with the interpretation of of the interested parties. And so I share your concerns also to make things right. I think my concern is that the impact that it'll have on the existing static signs and also the GLUC's rulings. And so perhaps there's something you could share with us, you know, their authority and the rulings that they make in these areas so that we move forward, we don't open another Pandora's box, and we don't do another injustice to another business entity.
I think that Public Law 3430, probably as well as the Bill 154, whatever it was, if those had passed, yeah, it would have been kind of an absolute approval and authorization. Bill 154 had basically grandfathered all signs that were legally operating. So So to me, I don't know, it could also be a little problematic after having granted that continuing authority to operate to electronic signs, that if a distinction was made for static signs and saying, well, the GLUC still has to, review the same process, and well, in my mind, it would raise questions.
Can I add that, the reason resulted from the Public Law 3430 last year to pass is just so that, like Fred said, to grandfather all the electronic signs because of the opinion of the AG saying that the GLUC does not have the authority to grant a sign. And that's the result of it, so that it can grandfather it in. Now, all of the variants for the signage, excuse me, they all have the same 2 years renewal date on it, whether it's electronic or non-electronic. And but for me, even from the beginning, and that's why I went to get a sign variance, is I want to do things right. If in the future if it requires to go back to get variances continue, I'll be happy to go back to get it. But my understanding is that the public law that was passed, 3430, was to basically just grandfather it in.
Right, it was intended to right what was wrong.
Right.
Right, and so I just want to make sure that we're moving forward and doing things properly. Thank you very much, and thank you for coming.
And thank you for your support.
Thank you.
Senator Perez.
I just want to thank you for your testimony today and your flexibility in being open to renewal of variances or renewal of application for variances, because I think that's important. When we try to provide equity to our businesses, I think it's important that the government also has an opportunity to review any kind of policies that they make and not make it absolute. So I appreciate that from you. Thank you.
Thank you. Senator Taisigui? All right. Yes, Senator Moline, you may close on bill. Sure, of course.
Thank you, Madam Chair. This is for the panel. If you can just summarize when you first started your business, right, and putting up your sign, what did you have to go through? Just a summary. What did you have to go through? What hoops did you have to jump through in order to get this going? Tell me the process of the government process for you to get approval, please, for the record.
Thank you, Senator Moreland. That's a good question because it's a process that we all have to go through, and it takes roughly about 2 years. It's when I finally got my variance. And I have a stack of papers here that we have to go through. We have to get engineering drawings. We have to get engineering specs so that the structure is going to withstand 175 miles wind, as well as all the building codes. We have to solicitate land management as well as everyone's approval. So here is, there's a long list of going through the different meetings that will, last through over the 2 years period. And then it would go through about, I think, maybe about 14 different government agencies like Parks and Rec, GWA, Public Works, EPA, GPA, Department of Agriculture, fire departments, Guam Economic Development Agencies, Department of Education, and Public Health and Social Services to make sure that there's no conflict with any departments. So after all of that is done, we have meetings at the GLUC to explain our projects, and then they review it, and it doesn't necessarily pass on the first time because they have other questions that we need to fulfill. Then eventually, maybe a couple months later, they have another meeting, and eventually I got my permit in 2016. Yeah.
And thank you. And one other thing, at any point, if those agencies told you, no, you cannot proceed, would you have proceeded and built this project of yours?
Would I?
If the government, as you were going through the processes, getting your stamps of approval for that last 2 years, if the government told you, you are not able to build this, we disagree, we're not giving you whatever approval we're supposed to give, would you have built what you did?
Of course not. I mean, I would go through I believe in the proper business practice, and that's why we seek the help of the GLUC, because I have studied other projects that's related to sign, and how they went through it, and I want to make sure that I'm in the same playing field, make sure that I got all my permits and all my process, and every T's are crossed and I's are dots, and make sure I get my business license and operate properly.
Thank you very much. Thank you.
Okay.
Thank you, Madam Chair.
Thank you. Does any one of you know, were you ever given a reason why, when the bill for the electronic signs was being voted on, they did not include?
I don't know.
Static signs.
I have here is the testimony from the director,
Yes.
Mike Borja at the time,
Mhm.
and he even I even watched the YouTube over again. He even mentioned about it, but there was no explanation why it was not included.
All right. Okay, well, I want to thank you again for being here, and Mr. Lam, I want to thank you for your written testimony in support of the bill, and I would like to let everyone know that we will continue to accept testimony until April 11. You may submit them to my office or here at the Guam Legislature Congress Building, or through email at senatorterlajeguam@gmail.com. Thank you.
Thank you.
We're going to continue in a moment with a hearing on another bill. Thank you very much. Bill number 7-35 LS, introduced by Senator Terlaje, an act to amend 61106 of Article 1, Chapter 61, Division 2, Title 21, Guam Code Annotated, relative to establishing an administrative fine for a member agency of the Application Review Committee, Department of Land Management, which fails to provide required reports and/or position statements on land use applications. I want to thank again my colleagues for being here. Vice Speaker Nelson, Senator Moylan, Senator Perez, Senator Taitukui. I would like to ask the sponsor to please discuss the bill.
Thank you, Madam Chair, for this opportunity and for hearing Bill 7-35. Madam Chair, Bill 7 makes it clear that position statements on land use applications are required to be submitted within 30 calendar days. The measure authorizes an extension period for submitting reports and position statements not to exceed an additional 14 calendar days, as provided by the Director of Land Management. And Bill 7 imposes a $1,000 fine for any director of a member agency of the ARC, Application Review Committee, which fails to comply with the conditions set forth. Madam Chair, the administrative fine proposed in Bill 7 reflects similar penalties, such as for violations related to the Guam Freedom of Information Act, FOIA. With the director of the applicable agency or department personally responsible for paying the proposed $1,000 fine. Madam Chair, Bill 7 was introduced at the recommendation of individuals familiar with the Application Review Committee and the challenges outside of ongoing challenges involving agency staffing needs. Madam Chair, I understand based on initial comments the Department of Land Management provided to your committee last month, that there are some suggestions on how to improve the current process, including the reestablishment of the 60-day window for agencies to submit information, an opportunity for an additional 10-day extension, and a second 10-day extension, and for a land use application to proceed without the input of an agency which fails to submit its position statement, suggesting a non-response as there being no objection on the part of the ARC member agency. Madam Chair, I've been on the phone with Department of Land Management, who informed me that they will be actually revising their testimony that they submitted earlier to the committee chair. They actually just called a few minutes ago, and on their way. However, I did mention that the public, my staff did mention that the public hearing did start already, and so that we did not want to delay this any longer because we have session. So they did say they would be submitting a new testimony to your office. So Madam Chair, I look forward to reviewing additional suggestions as well, if any, during the public hearing as we work to strengthen the current process and support responsible for developing going forward. Si Dios masi.
Thank you very much, Senator Taitagui. I'd like to read for the public's benefit the BBMR's fiscal note comments. They indicate there is no fiscal impact, but they, I think their summary is helpful. The intent of the proposed legislation is to amend the current reporting requirement of the Application Review Committee by 1, clarifying the time frame for submittal of reports and position statements to be 30 calendar days. 2, authorizing an extension period for submittal of reports and position statements not to exceed an additional 14 days, pending written approval from the Director of Land Management. And 3, imposing a $1,000 fine to the director of any member agency of the Application Review Committee that doesn't comply with the aforementioned submittal requirements. The Application Review Committee is comprised of 8 Government of Guam agencies, to include Land Management, Bureau of Statistics and Plans, Department of Public Works, Guam Environmental Protection Agency, Department of Agriculture, Guam Waterworks, Department of Parks and Recreation, and the Guam Power Authority. So these are the members that are supposed to be submitting responses, and now within 30 days. The proposed legislation stipulates that the subject fine for non-compliance in the reporting requirement shall be a personal fine to the director of the non-compliant agency and shall not be charged to the agency's budget. Any funds received from such fines shall be deposited into the rainy day fund and be utilized for eliminating or reducing any general fund deficit existing at the end of a fiscal year. Although the proposed legislation provides a potential revenue stream in the form of administrative fines to be received by the Rainy Day Fund, the Bureau notes that the legislation is administrative in nature and it serves as a deterrent for delays in the ARC's reporting obligations. I'd like to thank you for the bill. I think the bill points out the importance of this ARC. This committee is really the only Government of Guam input that we get normally on projects. And so we've got historic review, we've got review as to impacts on the environment, review as to impacts on the coast, review as to impacts on our water lens, and so it's very critical that these are made part of the records before the Guam Land Use Commission or any other approving body is considering that development. Are there any senators who have questions or comments on this bill? I would like to recognize the presence of Senator Jose Pito Terlaje. Thank you for joining us. Are there any comments on the bill? If not, then I'd like to ask Senator Taitagui if you have any. All right, then. We did receive written comments, testimony from the Department of Land Management. We've heard today that they may be submitting revised testimony. Their testimony pretty much says that they do not anticipate any fiscal impacts for consideration, and it is administrative in nature. The committee will continue to accept written testimony on Bill 7-35 until April 11. Please submit testimony directly to my office at the Ada Plaza Center, Suite 207, 173 Aspinall Avenue, Hagatna 96910, or to the mailroom at the Guam Legislature, the Guam Congress Building, or through email at senatorterlajeguam@gmail.com. There being no further testimony at this time, I will consider this bill duly heard and this hearing adjourned. Si Diyos masi.